What's up, everybody? Welcome back into our episode of The Lawyer You Know. I'm excited to hang out with you early this Saturday morning. It's been a minute since we've done this, and we're checking back in on Sheriff Mickey Stines, who is accused of ending the life of a judge. Maybe there was something going on in the background. He walked into his chambers and did the deed. It's all on video, but there are still defenses to be made. There are still arguments to be made. And in this hearing we're going to watch today, his defense attorney is going to argue that there was something that happened in the grand jury proceeding that should cause this court to throw out and dismiss this case, which would be absolutely wild based on the fact that you see the actual potential crime committed on video. Okay, we talk about evidence beyond a reasonable doubt. People are like, well, there's not going to be a video of every crime. This one, there literally is. We've done a few videos on it already if you want to check that out to get the background. But additionally, his lawyers are also asking for the judge to set a bond, a shockingly low bond based on what we know about this case. So we're going to listen to the arguments there and discuss whether or not we think the judge is going to give any bond at all, let alone as low of a bond as the defense is asking for at this point. So let's get into it. Of course, we're going to answer your questions. We're going to hang out here for an hour Saturday morning. Thank you for spending it with me. Let's get to it. So I want to mention off the top, because this happens sometimes and we have to make sure we're all prepared for it, because if we're prepared, it's not as shocking. It's not as annoying. John did something with my lights yesterday because we filmed something fun, me and John together, and it feels like they're shining in my eyes. But I want to mention to you guys the audio for I skipped the first couple minutes of the introductions just because it's brutal to listen to. The audio is so terrible in this video for about 6 or 7 minutes. But then guess what? They fix it. The camera angle changes. The audio is great for the vast majority of this hearing. So we will just get through this beginning portion. Eberna said, missing Papa George, wished he was on this one with you. He will be on some soon. He is going to travel with me next week as well. So we've been extra busy. It's been hard to kind of dive into anything really deep or pick up anything new. But some stuff has come up in these cases that has been interesting to talk about, like this one, a hearing. We've already been covering it. Hits the perfect spot. A ton of you guys sent it to me. So, when life happens and work happens, sometimes it's not always the perfect scenario and situation, but trial is going to end right as Adelson's picking up. So that's going to be something that we definitely jump into. And of course, continue to dig into everything you guys are interested in. I've recorded some fun videos for next week. I really hope you guys will stick around and watch them because they're really interesting. And I learned a lot doing them. And they have to do with like AI and things like that in the legal field. And a lot of it has to do with things that you guys sent me dealing with that. I'll leave it to that. But I hope you guys will stick around next week. Or come hang out next week, even if I'm not here live. Ashley, how long should your trial last? 1 week, 5 days. So Monday, Tuesday, Wednesday, Thursday, Friday. We should absolutely be done by Friday. We'll probably use every second of every day of that. But the way the court systems work here, they don't like it to go into the second week if you don't plan it. So the judge would not be happy about that. We're going to be done in 5 days. Okay, so let's get to it. And again, just realize audio sucks for 6 or 7 minutes. And then I'm going to adjust our levels once the audio gets good. All right, here we go. And by the way, I saw somebody put in the chat, does this guy remind you of Nate Bargatze? And now that you've said it, I kind of can't unsee it. And it's wild that somebody said that. And we just happened to be doing this video today, which I didn't plan on it. I am going to see Nate Bargatze tonight. So that's pretty exciting too, right? I will work in trial prep and then me and Whitney going on a date to see Nate. Going on a date to see Nate.
We filed a motion to dismiss on 2 grounds. Number one, under RCR 5.16, failure to provide or to have a transcript of the grand jury proceedings. Court knows RCR 5.16 requires that the testimony made in front of the grand jury must in fact be recorded. Now, we kind of came upon that surreptitiously when we were listening to listening to the grand jury tape, and there was a reference Your Honor, I don't know if the court has made that grand jury, can I speak to the content of the grand jury and decide for what I think?
Yeah, and for first record, the court has been provided a transcript, CD recording.
By the way, we're going to listen to it. I'll explain kind of the main arguments and big deal. There's some parts I can't even hear. Well, I'll explain to you the main arguments. Again, we're only about 5 minutes away from the audio being nice and crispy, so just stick with me because there's a lot of interesting stuff in this hearing.
Thank you, Your Honor. So there's a reference to one of the grand jurors that said, in our last meeting or in our previous meeting, and I'm paraphrasing.
By the way, the captions are not horrible. Even though the audio is horrible, if you want to just read the captions, you can also tell what they're saying.
And so at that point, we weren't aware of the previous grand jury hearing. And so I inquired of the Commonwealth. They did respond to it. The response was basically, well, we met with them. The purpose was just to get a subpoena for medical records.
So basically, there was a grand jury proceeding that he didn't get a transcript from, and he didn't even know existed until he read another transcript, which is why lawyers think things like this. And somebody mentioned in that transcript in our prior meeting, and he's like, well, where's the information on that meeting? And they didn't give it to him. And so that's one of his reasons to dismiss. Judge is not going to dismiss it because of that. But more is coming that I think is the bigger argument. He's still going to get into this a little bit more.
Thousands of hearings, and if you want evidence brought to a grand jury, this is usually submitted back to the hearing. I mean, there's no reason you don't have permission from the grand jury to subpoena. You send a subpoena, you subpoena the custodian to the hearing. And then the second piece of that that concerns me is that even if we presume that is what was going on, and I don't know, there's no recording, but if we presume that's what's going on, unless there was some sort of, telepathic thing going on, there had to be statements made to the grand jury that said, hey, this is this case, this is what we know, and I think the Commonwealth was making the distinction that, well, if you don't come in and raise your right hand and swear, it's not testimony. Well, actually, the distinction is sworn testimony and unsworn testimony. I'd submit to you that the only way that you're asking for a subpoena and you're basing that on some sort of probable cause or evidentiary standard that you want the grand jury to consider, which is the only thing that makes sense. You have to tell them something. They didn't walk into the grand jury room and say, just look at each other, and the grand jury said, hey, we'd like to have a correct subpoena. Now, I will say this, I do agree with the Commonwealth in their legal advice to the grand jury, and the grand jury deliberations do not have to be transcribed. But whatever was said to the grand jury, if you them to ask for or form their basis for asking for medical records, I think that should have been recorded, so we would have that available.
Basically, what he wants is the words, the Commonwealth. It's the Commonwealth again. People don't get flashbacks, okay? The words the Commonwealth said to the grand jury that made them ask those additional questions, discuss potentially getting medical records. We want to know what the Commonwealth told the grand jury. That's incredibly important, because what if they said, oh, wait till you guys see these medical records, specifically look, this, that always means somebody's guilty. You have to say, we're going to indict this person if you see that, because we know we're going to convict them 100%. Obviously, I don't think they did that. But if they were trying to twist and turn and even mislead the grand jury, which more on that later, we want the transcription because that's how we can prove it. Truth be told, Peter, when and where is your trial? I'm local. So it is public. It's in Pinellas. I don't think I'm going to make it a habit of like promoting that on here. I don't want to make it about me. I don't want a bunch of people to come to the trial to watch me. It's a really important week for my client. So I'm going to focus as much as I can on that. I love you and appreciate you for wanting to come hang out. If people end up being at a trial that I am doing one day and watch some of it, awesome. And we can talk about it then, but I don't really want to use this to promote that or have people come watch me do something. If there's ever one streamed or on video, hey, have at it. You guys will watch. Maybe we'll share it on the channel and stuff. Susan said he's guilty of sin. Marissa J said he at least takes it under advisement. Yeah, well, there's more coming, but she's talking about the judge. Not sure how I feel about Mickey yet, but innocent until proven guilty. And I want to read these two back to back because it's important. Even with a video of the person committing a crime, we are learning in this case that there are other things at play here. Is he going to walk home free? Highly unlikely. Okay. But when you have maybe mental health things going on, is there something else other than prison somebody could end up in? Yes, it's happened. We've had cases like that with insanity defenses. Additionally, is there a mental element that can affect what level of charge he should be charged with, pled to, or convicted of? Absolutely. And that's another part of justice. It's not all innocent, guilty. There's a lot of gray area in the middle. And some of that is, what is he actually guilty of? Just because the cops or the prosecutors say it's X doesn't always mean it's X. And sometimes a lawyer's job is to fight until you get the appropriate charge. And then your client says, fine, I will plead to that. I will do the time for the crime that I committed, but not something worse, that elements I do not fit. And that's, I think, something we're going to see in this case. My pal Sal said, YouTube won't let me hit the like button. Well, I think we should just keep trying. Everybody make sure you try to hit that like button. If you hit the like button, let me know in the comments section. And Ashley said, now all I see is Nate Bargatze. I know. Somebody did it to me too, Ashley. So sorry, I had to do it to you guys.
And I think 526 requires it, and really is that going shall form a motion to dismiss. I can address the other area judge. Okay. And the second area judge, I don't really think Kendra, that may need an evidentiary hearing. It may not. I mean, I'm not sure. I'll leave that to the Coleman office to get the response to that. But in terms of the other portion,
You're talking about the statement to make.
yes, sir. As to the second portion of my motion.
Sorry, I was muted. Now we're getting to the second argument of his motion, and get your ears ready, because now is where he says the prosecutor misled the grand jury. This is a big deal. If this is true, this is something that could be a major problem. And again, people think Mickey Stines guilty as can be, absolutely committed an unlawful act, horrible thing, should never have done that, whatever the circumstances were. What crime? Again, we're still looking at it. Innocent until proven guilty. We see they have a lot of evidence against him, obviously, with a video. That is why prosecutors cannot be doing things like misleading a grand jury and potentially having a problem where everything gets thrown out. And then we start to argue, well, do they get to refile? Can they bring it in front of another grand jury? Is that going to be a problem? Is this dismissed with prejudice, without prejudice? We do not want to have to go down that road in these types of cases, in these situations at all. We need to do it right as prosecutors. We need to be above board. We need to make sure we are following the law so that we can convict people that commit crimes. And those convictions stick.
It's based upon Commonwealth behavior, and Mr. Cox actually handled Mr. Baker in that case. We all know it in the prosecutor's community is the aluminum bat case. The detective goes in and testifies and says, basically it was an aluminum bat used, this one used aluminum bat. In reality, it was a wooden stick or something like that. And in that case, we were following
He's giving the example of a case where detective says person used an aluminum bat when it was really a wooden stick, and how you can mislead the grand jury. He's just kind of explaining that here.
Based upon that testimony being misleading, granted, the Supreme Court sent back and said, look, if you give evidence to a grand jury, you get misleading. And this
seems like a simple enough proposition, right? If you give evidence to the grand jury, you can't mislead. Seems fair.
The bigger debate really seems so when I look at, the grand jury transcript, Judge, and again, without getting into the case of the Eastern report, one of the really things that bothered, one of the big things that bothered me was the grand jurors, first of all, they spent nearly half the time asking questions. And a large portion of those questions concern the mental health of Mr. Stines.
So, isn't that interesting? It's not like it's a surprise to the Commonwealth that the defense is moving forward with some kind of mental health element to their defense, right? Whether it's a complete bar, whether it's to get a lesser included, we'll see how that continues to develop. But there was a lot of discussion about mental health during the grand jury proceeding while no defense lawyer is there. So they're just getting the Commonwealth's explanation, which is totally legal and how it goes. But it's just always easy or good for me to think about what that must be like sitting in there as a grand juror when all you're hearing is one side of the story. How do you ever do anything else? Right? You can't go home and talk to your friends about it or your uncle who's a lawyer. You can't go home and ask, well, this is how it was presented to us today. What do you think I should do? That's how you're getting it. So that's why you can indict a ham sandwich, people say.
And the last question before the grand jury retires from deliberation was, so he was in the same mind as far as the investigation is now, and the answer is yes. That's Detective Stamper testifying to that. Now, first of all, probably not an appropriate thing for Mr. Stamper, Detective Stamper, to be opinion on, but the rules of evidence, I get it. I mean, if there's an evidentiary issue, that's not what we're talking about. But here's the thing. If you're going to let a detective testify about sanity and render an opinion, that grand jury takes that to heart.
So the detective testifies about mental health. Is that appropriate? Is that misleading? Micah, so I looked on maybe 10 different channels and the first 9 minutes of every single one was this bad. I didn't see any better. In about 30 seconds or less than 30 seconds, the sound is about to pop in and be good. So all of you that stuck around through all this, I appreciate you. You're the real riders. The sound is about to get a lot better, a lot better. Tara said, I'm pretty sure I've seen Nate Bargatze's sister in here in the chat. You know, her name is Abigail, I believe. Have fun tonight. It's a great show. Well, that happens to be one of the reasons why I'm going to the Nate Bargatze show, and I'm excited to meet Abigail. She hooked it up, and it's going to be fun, and I couldn't be more excited. I love watching comics on Netflix. I've never been to a comedy show. Actually, that's not true. I went to like one comedy show in college, like Hole in the Wall, No Names. But I've never been to like a real comedy show like this. I'm so excited.
He's seen all these facts, and I submit to you, without getting, I can't reference the report, but I'll say this. You're hard pressed to find much in the way of the investigation that would support the adverse. And so, this is what I believe. I believe that had they not been told by, it's very real. And you know,
and now we get the beautiful sound of normal courtroom audio. Congratulations, everybody. Pat yourself on the back. You made it this far.
I can think of one witness, an attorney, who specifically said, I think he's had a psychotic break. And so to say that your investigation so far is showing us in the same mind, yes, I think there's at least enough there, Judge, for let me put the witness up there and ask him. Right. And then, Your Honor, there are additional items that I think are also of concern. There's a question.
You've cited those in your.
I cited those, Judge, and those are additional items. And if the court doesn't want me going about each instance, I'll just say that is the sort of thing that I think we need to know from Detective Stamper. If you knew these things, why did you answer this misleading way? And I think it's reckless at best. And I don't know. We need a hearing to find out, Judge, what I'm asking.
Right.
Unless the court wants to certainly take it under submission and dismiss without an evidentiary hearing, we would request that as well, Judge. But if not, then we'd ask to be able to put on.
Sure.
Thanks, sir.
Ms. Dahl.
Thank you, Your Honor. Your Honor, the Commonwealth is of the position that we certainly acted in compliance with the rules of criminal procedure here, the rules specifically that were cited by defense counsel. And we would ask that the court to dismiss the motion, to deny the motion to dismiss the indictment as it's wholly without merit. Your Honor, here, counsel is correct in citing Rule 5.06 that we could have unilaterally issued a grand jury subpoena to obtain these mental health records. That is the power that the Commonwealth does have. However,
And that's always the hard part of a defense attorney. It's like, Judge, they did this. It's like, yeah, well, we could have done 50 different things that got that. We have the power to do that. Doesn't make a difference. And so much of that is like, if the end result would have been the same, what exactly is the difference? Are you really going to dismiss this case over it? Now, that's sometimes why law enforcement or prosecutors start to get closer and closer to the line and step over the line because they're like, we could have done it anyway. So these arguments are not usually my favorite, even though legally they are usually a winning argument and appropriate. Peter, do you think the judge that said that about indicting the ham sandwich regrets it being quoted all the time? So here's what I'll say. I get where you're going with this, but I'll take it and I'll use the Uno reverse card on you. How many judges and lawyers do you know hate being quoted all the time? I bet he's like sitting back like a king. I don't even know if they're alive still. Sitting back like a king, like, haha, look at that line. I was right. Everybody used it. And he was right. And it was a great analogy. And it helps everybody really understand what the process is like. Bok Grandma. I have several Lawyer You Know shirts, but the one you're wearing today looks so good. I'm going to have to order that one. I love it. Every time we get like a new either material of shirts, which this one is new, and I really like the way it fits, or a new design, John sends me like 20 samples. So I have so many different kinds of shirts. So I like to try to wear them when I'm on stream. It's fun. Jen said, that's going to be a great show. Love Nate Bargatze. He is a Tennessee favorite. Awesome. I wonder if he or his family is interested in this case, kind of in their area-ish.
Taking an extra step in the interest of transparency, as the grand jury is an independent investigative body, and to ensure that there was no argument that we were usurping our grand jury subpoena power, we appeared before the grand jury on October 17th of 2024 without a witness, specifically to ask for these mental health records from two different providers for the defendant. We appeared at that time. There was no witness. There was no testimony presented. Counsel, again, is correct that pursuant to Rule 5.16, had testimony been presented at that time, it should have been recorded and would have been required to be recorded.
Who appeared from the Commonwealth when that request was made?
Myself and Mr. Steele.
Okay.
Only the special prosecutors were present. No witnesses appeared on behalf of the Commonwealth.
Right.
And so, Your Honor, the rule
Why do you need witnesses when you can just have the prosecutor tell them, right?
is clear. It requires testimony in order for there to be a requirement for recording. And there was no testimony presented at this time. And
Do you hear that? So it's like the rule only requires if somebody's testifying for us to record it, not if it's just the prosecutor talking to the grand jury. So if the prosecutor says, oh, he had a mental break, or he didn't, he was mentally fine, or you should absolutely indict him because of this, or you guys are stupid if you don't do it this way, you'll never get picked for a grand jury again unless you indict this person. We don't need to have a record of that.
I think that is apparent. The court now has a copy of the actual recording of the grand jury proceeding for the testimony that was presented on November 21st, the only time that testimony was presented. And I believe a review of that testimony, some of which is referenced in the Commonwealth response that has been filed, will show, based upon the questions that were lodged by the grand jurors, the only thing that was requested at that time were this grand jury subpoenas for those medical records. I think that's reflected in the context of the recording of the grand jury presentation.
And as an officer of the court, are you representing that was the only request made?
I'm sorry, Your Honor.
Are you, as an officer of the court, representing that was the only request made?
Yes,
There
Your Honor.
was no peripheral commentary or anything?
The judge is like, let's try the trust me bro thing. Are you telling me that that's true? And I don't blame the judge for this because there's only so much you can do if there's no transcript. And if the rule doesn't require it, why wouldn't that be in the grand jury transcript? It depends. Every jurisdiction is a little bit different about what's required in the transcript. And I some of what was said in the very beginning was hard for me to hear, but it sounds like the defense attorney was arguing it should have been in there. Prosecutor saying the rule says it doesn't need to be in there. So if the rule says it doesn't need to be in there, it's not going to have to be in there. And the judge is like, well, let me ask you this, counselor. And again, I don't blame him. At some point, we've got to trust lawyers. Lawyers have a duty to be honest with the court. More on that in a video later this week. What happens when you're not honest with the court, either intentionally or even accidentally, what that can do to you. So the court's trying to get to the bottom of it, trying to make a record of what exactly happened. Was there any extracurricular conversations that didn't end up in the transcript? Or was it really just like, okay, we're going to get these mental health records. We're going to get a subpoena for the mental health records. Dana said Nate's shoe game is fire too. Well, as a guy who loves shoes, I'm a big shoe guy myself. I can't wait to see what he's wearing.
Think of that.
No, Your Honor.
Just-
Just specifically request for those grand jury records, for the mental health records pertaining to the defendant, one from ARH and one for Leslie County Detention Center.
Mr. Gilmore.
Just a point of clarification, if I understand your question, as you can imagine, nobody in the grand jury room needed to be told what case this was or anything regarding the fact.
I would think that's a safe assumption.
When we went in and we said, we're the special prosecutors in this case, we're here just so we can get a grand jury subpoena for mental health records. They began asking questions, of which we did not have an answer to.
Right.
We never answered any substantive questions other than that. That's something we're looking at. That's part of the investigation. Those matters will be presented to you later. There was never, of course, at this point in time, the preliminary hearing had already been had. The video was already out. Other videos had been released. There was nothing we added at all to, or any conversation regarding the case other than the investigation and why we needed the records.
All right.
That would have been it.
Go ahead, Mr.
And Your Honor, additionally, we asked the grand jury to memorialize what was being requested and as far as the grand jury subpoenas in writing, which was authored by one of the members of the grand jury and signed off on by the foreperson. The verbiage of that is reflected in the response as well, but specifically which records they were requesting and authorizing via grand jury subpoena. So those grand jury subpoenas were issued. The records were received. Those records were then promptly provided to counsel for the defendant on December 4th of 2024 in the very first discovery period. So in compliance with our discovery obligations, Your Honor. So the Commonwealth believes it's clear based upon the rules of criminal procedure that we acted in compliance with those rules. We have additional arguments as far as in the Jackson case. However, the Commonwealth does not feel it's necessary to delve into those at this time unless the court would like to hear them as they're reflected in the record.
I've read your motion, or I've read your response.
All right, thank you, Your Honor. So clearly, we do not believe any evidentiary hearing is required with respect to the argument that there was no recording made. That is apparent from the recording that the court already has. So no evidentiary hearing is required. As far as the second argument, turning to the actual content of what transpired and what Detective Stamper testified to in the questions that were asked during his testimony to the grand jury in November. Your Honor, I think defense counsel is conflating the role of a grand jury proceeding with the role of a criminal trial. It is very clear under the law that they are distinctly different proceedings. The grand jury is an investigative body. The Commonwealth has no obligation, as reflected in an abundance of case law, to come in, to present exculpatory evidence, and to attempt to mount a defense for the defendant. That is not the Commonwealth's obligation. Additionally, the rules of evidence, particularly Rule 1101, does not says that the rules of evidence do not apply to grand jury proceedings. So hearsay, opinion testimony, the right to remain silent.
Isn't that wild, right? I mean, every time I hear somebody argue about what a grand jury proceeding is like, I'm like, man, this is how we do it here still. It just seems so crazy. But I mean, sometimes you don't even need grand jury, right? You just need probable cause. So I get it. And I get the point of it. I think grand juries are almost like, I don't even think they really serve that big of a purpose personally. It's like, you guys think somebody did it, let's just move forward on it, right? They are a protection in cases like, if you remember back to Deshaun Watson, they return no bill. So once in a while they do return no bill. So I do get it as an extra layer of protection. I just don't think they're that effective personally.
All of those things are not required to be adhered to at a grand jury proceeding. If they were, our grand jury proceedings would be the same length as a criminal trial. It's not tenable.
The reason a grand jury proceeding for 30 minutes is the same as a 3-week trial.
Exactly, Your Honor. And so I believe.
Can you guys guess where the judge is leaning? Can you guess where the judge is leaning on this issue? I can tell you right now, this is all going to get denied. It is interesting. And it was an interesting argument made by the lawyer. And more than anything, it's just, again, an educational opportunity that just because somebody's indicted. This is how they get indicted. It's basically if the cops think you did it, you can get pretty far down the line of being criminally prosecuted. So just remember that. So when people try to say, oh, cops arrested you, prosecutors think you did it, the grand jury even indicted you. When somebody tells me a grand jury indicted me, that means little to nothing as far as whether or not somebody's guilty beyond a reasonable doubt. Because as she's making the argument correctly, legally appropriate, I think she does a very good job making this argument. I have nothing against these prosecutors. You know, they seem to be doing a very good job in this case, but they explain to you just how low the bar is in the grand jury proceeding.
I believe counsel's arguments are confusing the two, the purposes of the two. You know, hearsay is presented routinely at grand jury. Opinion testimony, such as Detective Stamber's testimony, is presented routinely at grand jury. These are commonplace and they are permitted under the law.
You would agree, though, you can't be intentionally misleading.
Absolutely, Your Honor.
Imagine if she said, you know, I don't agree with that, Judge. I think you can be intentionally misleading. It's like, at least we have that bar. You can't, and you notice how he said intentionally misleading. So there are scenarios where you can say something and it can be misleading, but it wasn't intentional and it would still get past the grand jury.
Certainly. And Your Honor, the Commonwealth is of the position that an evidentiary hearing is not required. Everything that transpired when testimony was presented to the grand jury in November is captured on that grand jury recording. The Commonwealth cannot conceive of a reason to haul witnesses in to talk about what transpired because it's on that recording. And so we do not believe that an evidentiary hearing is recorded. Or is required, sorry, Your Honor. So, Your Honor, again, the court has that grand jury recording. We would ask that it be filed under seal as it was a grand jury proceeding. And we would ask the court to deny the defendant's motion to dismiss the indictment in its entirety without any necessity of an evidentiary hearing. And we would rely on our pleading submitted as well, Your Honor.
Thank you.
Your Honor, may I just briefly reply, Your Honor?
Briefly, yes.
Yeah, Judge, so I mean, I haven't heard anything. I said from the beginning, Judge, I understand, we're talking about the rules of evidence. The reason I cited to the issues where there were things that normally wouldn't come in is because there were instances throughout the grand jury when the witness was about to answer something the grand jury asked for, and it was shut down. I was contrasting.
That's not unusual, Mr. Pollard.
Oh, I get that, Judge, but my point is this: if you put that into context with what they let testify, then I think ultimately, Judge, if we put on that evidence, will show you that this grand jury was misled. I mean, the statement alone, to be honest with you, the statement alone of rendering opinion on saying it is completely, in terms of, I get you don't have to be an expert, Judge, but if you say it, you can't mislead. And then, so I'm not asking the court to look at whether things should be admissible or not. That I'm not at all. My point is that the grand jury is an investigative body, and they don't get to dictate what they hear if the grand jury is asking for additional stuff. So in other words, if they ask a question and it's germane, I'm not talking about relevance, but if it's germane, it's their grand jury. It's not Commonwealth grand jury. They're the investigative body. And so the reason I cited to the things that
Dana, I threw your question up there because the answer is yes. He's kind of going through that now.
I thought shouldn't have came in is that it contrasts with other things that I think they asked and never got told because the questions were reformed. And that's why we're asking for the.
Well, thankfully, I've been part of about 20,000 cases being presented to a grand jury. I'm going to listen to the recording, and I'll be happy to review that.
And Your Honor, if the Commonwealth
Briefly,
may,
sure.
thank you. I would like to make a distinction. The Baker case, we're talking about misleading.
That's how I prefer court to sound, by the way. May I respond, Your Honor? Yes. If the Commonwealth may, Your Honor, yes. Be respectful to the judge. It's very easy. And then you don't just shout out. You don't just stand up and start arguing. You don't argue while you're sitting down. This is kind of what I like, even state court, right? Because this is how federal court is. And usually the judge will be like, no, I've heard enough in federal court. But some state courts are a little too loose for me.
To the extent of an aluminum bat
Understood.
versus a wooden stack
Sure.
stick. I don't think there's nothing even alleged in the pleadings, even if you take everything in the pleadings that's been said today by the defense as true, that would be tantamount or even close to that, Your Honor. You know, as far as the mental state of the defendant at the time of the offense, that wasn't even an issue at the juncture of grand jury. That hasn't been raised since has been raised since by the defense counsel. So, Your Honor, again, I don't believe that those arguments are well taken. We would ask that you deny their motion to dismiss in its entirety.
Understood. All right, and I will get an order out on that. One, if I need to hold an evidentiary hearing in it, if not, I will on it appropriately and distribute that. After review, I've got the CDMS Madam Clerk, place that under seal with the conclusion of the hearing. I am going to take a copy of it with me to review for purposes of reviewing the pleadings.
Yes, sure.
All right, next in regards to the bond hearing.
All right. Before we get to the bond hearing, Nate's clean and fun. Have fun on your Bargatze date. Slinky, I am so excited. I've watched a lot of the Netflix stuff these are done. He has like my favorite joke I've ever heard a comedian tell, which is like when the school calls and he's like, you saw mom's name and you saw dad's name and you decided to call dad. And then they're asking like, what bus is she on? And he's like, I have no idea what bus she's on. And they're like, fine, sir, will you just come pick up your daughter from school? And he's like, okay, what school does she go to? It's like my favorite joke ever. I've told it a million times. I've botched it a million times probably. But yeah, one of my favorites. I can't wait to go see him live. Brian, hey, Pete, when are you going to cover the legal atrocities happening to Aiden Carney's case? Too thin-skinned. Okay, somebody sent me a screenshot of some of the comments on Twitter because I don't read the comments most of the time. I've learned, I'm growing, you know. And once they sent me some, I read some of them and it made me laugh. It's like, first off, as I've said before, and some people said on Twitter, Adelson trial coming up. I'm already fully invested into that, especially with the Dan Markell connection. Have my own trial this week. I'm not digging into any new cases. And all I know about Aiden Carney's case is he is indicted for witness harassment or whatever. I don't even know. Like I literally, that's how much I haven't even looked at witness intimidation. I don't know anything about it. So I'd have to go into all the background and I've fallen into this problem in the past where I cover too many cases and don't get deep enough into the details. I'm sure all of the people following that case would be gracious if I got a detail wrong on something, number one. Number two, the way everybody thinks they're getting me to do it on Twitter ain't the way that we do it here on The Lawyer You Know, where I say the subscribers choose the content. And the way subscribers ask and throw stuff at me and send me some articles and have questions on it, that's the way the content comes to this channel, not the way people think that they like can guilt trip you into doing something or be like, you're too thin-skinned. Like, brother, you don't know what it's like on the other side if you think I'm too thin-skinned. So that's not going to work and probably makes me less interested in it if I'm being honest, because I'm not interested in that type of a discussion in the chat with people asking questions. This is a channel where we learn together. We walk through cases together. Yes, we highlight injustices together. I am not a journalist. I am not a reporter. I talk about it from the legal side, from a lawyer. If I'm going to talk about this case, frankly, I would talk about it with Mark Betterow. If it goes to trial, I'll follow the trial, but it's probably going to be impossible for me to ever dig into all the crap that's happened in this case and learn a whole new cast and characters to go through it. So too thin-skinned is my favorite part about that comment. Congratulations. Sunny Days. You should listen to Defense Diaries regarding Mahendra Patel kidnapping case regarding the grand jury. So listen, when we talk about grand jury proceedings and lawyers, are saying that the Commonwealth or the prosecutor lied to the grand jury or misled the grand jury. What I will say, to give the Commonwealth, to give prosecutors, to give law enforcement a benefit of the doubt here, way more defense lawyers say a grand jury has been lied to and has been misled than actually happens. Okay. So I don't want to make you guys think that like every single prosecutor goes in there and lies to the grand jury. Now, I think most grand juries, if a defense lawyer is there, they can be like, that's not true. But we've all seen it in trial. And half the time you guys are like, I hate that scummy defense lawyer. It is true. He's calling these witnesses liars. They're not liars. What are you talking about? That's not true. Well, that's what happens sometimes with the grand jury proceeding is defense lawyers are like, that's not true. That's not true. That's the point of a defense lawyer. We go in there, we can pick holes, we can make arguments. And when it comes down to what a jury actually decides, that's why it's supposed to be an even playing field at trial, because the defense lawyer is going to be there to make these arguments, make these objections, try to keep certain things out. That does not happen at the grand jury proceeding. You do not have the right to a defense attorney the vast majority of the time. So that's why it's just a different ball game. So many times people can, and I'm not saying Defense Diaries is wrong, but I know nothing about this case. Once again, not going to be able to dig into this case at this point, this Patel case. But it sounds like they're doing it. And I'm sure a lot of people are doing Turtle Boy's case, which is great. And I think that's what's so great about YouTube is there's so many people on here able to tackle so many different cases And I think that's amazing. And sometimes we're all seemingly covering the same cases. Most time we're all covering different cases in different ways. That's what I think is cool. And that's what we'll continue to do on our channel, is answer your questions, the case that you guys are interested in. Or something else. We'll get to it.
Yes, Your Honor.
Well,
Again, Carrie Bartley for Sean Stines, Judge. And we filed our motion for the court to, and it's been back quite a ways now that we
Sure.
filed that, but we did ask the court to kind of hold
which is
off.
not abnormal. I know we've had some procedural things and evaluations, so
Absolutely.
that
And
is
that's-
something that had to be done.
We asked the
first.
court to hold off on setting it for an evidentiary hearing until after we received that report back. Judge, you know, I think by pursuant to criminal rule 440, I believe it is, we're entitled to an evidentiary hearing. I think it's going to be necessary for us to bring witnesses. We had some witnesses lined up. And I think it would be necessary for the court to hear that evidence and make its findings on whether there are several factors by statute that the court has to consider when determining whether bond is appropriate. And there's an added level here, and I anticipate the Commonwealth will argue that Mr. Stines is not entitled to bond because of the way that this case is charged. Okay, so in that situation, Judge, they're going to have to put on proof. It's actually their burden to show the court if that is in fact what they argue, and I don't know, I'm just anticipating, but it is their burden if they're trying to preclude him from bond at all to put on proof that guilt is evident, or the proof is essentially, you know, there's great evidence of the proof, right? And so I can anticipate what those arguments are going to be. I can anticipate all of that, Judge. But I think, given what we know, and again, without putting any of that on the record today, given what we know now, I think we'll have a heck of an argument on bond.
What would be your proposed bond, in light of the circumstance?
Absolutely. And given what his income is, given what he's able to post, and I think that's what the statute requires the court to look at, is what he could reasonably post. We would
Public
propose.
safety is a factor also.
Absolutely. There are several factors, Judge. I just think
She's like, Judge, we really think he should get a bond. And she's trying to come up with these arguments as to why he should get a bond. And of course, she's going to say public servant forever. The judge is like, and she's like, he's not going to flee. Judge is like, public safety is kind of a big deal, right? This guy walked into a room in broad daylight, basically, and did this to a judge while a camera is rolling and walked back out. I don't know that we want this guy out on the streets. And he's looking at forever behind bars. So he doesn't have a lot to lose from trying to flee or trying to do something or even hurt himself if he gets out on bond. This is one of the wildest types of bond arguments. It's almost like she's just completely avoiding what the accusations are, what the evidence is against him. And again, you know, I'm a big innocent until proven guilty guy. By the way, if it needs to be said, Turtle Boy is absolutely innocent until proven guilty. Absolutely. Every criminal defendant is. But every criminal defendant is not treated the same in the bond process, because the amount, like Turtle Boy, out, not in prison. This guy is sitting there because of the video of the very dangerous crime, or very dangerous act, I should say, that he committed. And because of that, the judge really has to take public safety very serious here. Very serious.
that in terms of what the amount would be, the court has to look at what he could reasonably post if he is in fact entitled to a bond. So our proposal, Judge, would be 50,000 cash for property with any non-financial conditions that the court would require of him. The court could set a host of non-financial conditions, Judge, as you well know. However, I think that given Mr. Stines, and again, without waiving any of our,
Absolutely.
any of our ability to put on proof, I would ask the court to take a look at the fact that he is, the lowest possible risk level that one human can be in terms
I'm
of his
gonna stop it
pretrial
for a second.
service.
Pretrial,
He is almost the lowest risk profile you could be. I'm hoping she was going to say risk of flight. I'm hoping that's what she was going to say and not of anything else, because man, would I disagree with that. You Killing Me, Smallest, Pinellas, St. Pete, or Clearwater. I'll just leave it as Pinellas for now. Montana Lil. Aaron Spencer out of Arkansas needs covering. He needs as much help bringing daylight to his case. We did a video on him. I'm very interested in that case. I think it's very interesting as well. hard for me to do a deep dive. The reason we did a video is I thought the trial was going to be coming up at the end of this year. They've continued that trial. So again, when that case goes to trial, we will be all over it for sure. Sunny days, no worries, but Mahendra Patel has a better case than Karen Reed for suing, in my opinion. I followed the case here in Georgia. No, I do not disagree with you. I don't know enough about the case to really have a comment on it. The Aiden Carney case is actually so interesting. The corruption runs so deep, and he was set up, and they have it all documented. It's bananas. I'm not disagreeing with you that it might be very interesting and that the corruption, I'm probably 100% with you that the corruption runs so deep, knowing where the case is. Me not covering it is not disagreeing with anything that you guys are saying. Okay. Let me be clear here. Regardless of what anybody says about me online or, even Turtle Boy himself, whatever he says about me, whatever, that's not why I'm avoiding it. Not because I disagree. He very well may be innocent. He very well may be guilty, but they did something wrong to where the case should still get thrown out. Like we say, you have to hold law enforcement and prosecutors to the burden that they have to do things that are right. And if they don't, those cases need to get dismissed, even if somebody's guilty, right? All the same principles that I apply to every case that we talk about apply to that case as well. Aaron Spencer is worth a look. I agree with you. I just can't go do the humongous deep dive at this time on it. But again, I know stuff is out there on it. And when it goes to trial, we will be ready for it. Rubicon, Beto is Turtle Boy's attorney, so he might not be able to speak on it, but I understand the perspective. Yeah, I know that was my point. And I have talked to Beto about things surrounding that case. And I am interested to see his thoughts after the fact too, on what he thinks about it. I love Beto. I think Beto is awesome. He's a good dude and we still talk. He's awesome. He's in good hands.
Risk assessment, with all candor to all parties, is something that, as a prosecutor, now as a judge, I don't have the utmost faith in.
I understand, Your Honor, but it is also something that the statutes require the
Understood.
court to take a look at. And there has to be some other evidence that the Commonwealth can put on, or some other evidence in front of the court that he would be a flight risk, that he would not return to court, that he would be a danger to himself and the community. And again, I think that's why it's important for us to be able to put on proof and to be able to put on some of the stuff that's in that basic piece of report. I think that when we are able to show the court what's in there versus, all the other things, I just don't think there's anything to show that he's a flight risk. There's nothing to convince the court that he would be a danger to himself or others. And I understand why we're here, Judge, and I get that. But the courts have said consistently, and it's, I believe, the Abraham case, that you have to look at something other than the charge.
I
It has to be
understand,
something else, right? We can't just look at the charge to get.
but that can be factored in.
Absolutely. So, Judge, I think we're going to need that testimony and we're going to need that report. I would ask the court, again, without waiving anything, I would ask the court to consider setting a bond. The court, of course, can do that at any time. And that would be our requested bond, 50,000 cash or property. If the court wants to hear just a little bit about what we would put on, again, Mr. Stines is a member of this community for his entire life, born and raised here. He has a great deal of family support through all of this, as the court can see. He has a wife and
I totally get her argument, and I totally understand defense attorneys having to protect the record and trying to fight to get her client a bond. But I think all of you guys watching this know how this is going to end. I don't care if the judge takes it under advisement or not. He is not going to get a bond. And if he gets a bond, it ain't going to be 50 grand or whatever she asks, which would be appropriate if you wanted him to be able to get out based on how much money he has. But it's just not. Jen said, Peter, are there some states that don't do grand juries? So yes, there are kind of three types. There are a couple states I don't think that have grand juries at all. And then there are some states that you have to do it through a grand jury. That's how you have to indict. And then there are some states that you can either do a grand jury or not, right? You can just go forward on probable cause.
daughter that he can still go home to today. He was a member of law enforcement for basically his entire adult life, up until the point of his arrest. Is a respected member of law enforcement, a respected member of the community, and frankly, Judge, everything we've learned about him since then corroborates that. And I would have testimony to that.
And again, this is a tough one because as I'm listening, I'm like, yes, all that stuff should matter, right? Dedicated servant of the public, protector of people, cop, all of that is great. And if we didn't have a video, maybe there'd be some more discussion here, but we do. So we can't act like we don't have a video of him committing a heinous act.
No evidence that he would be a flight risk. Nothing. He has no failure to appear on his record. He has no, property in the Bahamas that he can run off to. There's nothing. This is a man with a great respect for the law, and he's built his life around upholding the law and serving his community. Just there's nothing that I've seen that anyone's seen. And frankly, when we put on our proof of the court, we'll see there's nothing to say that he would not return to court. There's nothing to say that he would commit another offense. There's nothing to say that everything in this pretrial services report, respectfully to the court, is not correct, that he's a low.
There's nothing that would say he would go commit another offense. This is why I think that's a tough argument in this case. There was nothing to say that he was going to go do this. It's not like anybody knew or thought he was going to go do this. So how do we know he doesn't think something else is going to be involved, or again, has another mental break and somebody else is a new target? Like, that is something, as if I'm a judge, I'm not convicting him. I'm not throwing him in jail forever like he's a criminal saying you're going to get this sentence before your trial. That's not what I'm saying. But public safety is incredibly important to me if I'm a judge making this decision. And this case just is not right to let him out, in my opinion. Dirty truck. Check out State v. Roderick Teasley in Georgia. The state lost the weapon, so no ballistics could be done to exonerate Teasley. Effed up Fanny, free Teasley. I haven't heard anything about this. We've had a case where evidence has been destroyed or lost, and it's sometimes to do with testing. And it depends on the judge a lot of times with how they look at that. Just thought I'd compliment you, Peter. You've done awesome guests you've had some awesome guests on the show. I really loved the show you did with the Tallahassee lawyer regarding the Adelson case. Very interesting interview. Thank you so much, Sunshine. And I only pulled this comment up to say Monday is another one of those that I really, really liked. By far, the most interesting discussion about the civil lawsuit between the O'Keefes and Karen Reed and the bars. By far, most interesting conversation I have seen or heard. I mean, maybe I haven't heard a lot or seen a lot, but that I've had on that case. So please check it out and meet a new lawyer to this channel. Some of you guys may already know that lawyer, but he specializes in those types of cases as well. So we put our heads together and really dig in to that case. I really enjoyed that conversation. Surely what he is now is more relevant. So yes, and that's a good point, Linda. The court is going, yes, we take somebody's history and what they've done their whole life. That comes into play. That's important. But there's another additional act and fact that the court has that we have to consider with his body of work, for lack of a better term. And the body of work of Mickey Stines may have been amazing, but the judge still has to consider that last act before he was thrown in jail.
0-0 risk, Judge, because this is a man who, again, I mean, there's, with all due respect to the court and to everything that, for the reason why we're here, the court does have to look at something other than the offense charged. I know it's a good one.
I understand that, but this, you would have to admit, is a unique fact circumstance.
Absolutely.
This is not a whodunit. I mean, the actions are very evident. What the end result of that is, that's the purpose of the case as we're proceeding.
I think that perfectly summed it up. He just basically in one sense said what I've been saying all video. And so I appreciate that. Got to give the attorney credit for trying. I agree. And she's not being nasty. She's not tearing anybody else down. She's not saying anything inappropriate. She's not slamming her hand on the desk. She's not calling anybody names. Like, I think she is doing a great job. I have no beef with her making this argument completely. We're just talking about here what we're thinking, how the judge is thinking, things like that.
So, all right, I understand your argument. Still,
Your Honor, if I may respond, she went through a lot of the statutes. Unfortunately, she forgot the Kentucky Constitution, Section 16 says that all people are entitled to bail unless there's a capital offense. And the word she was looking for is when proof is evident, the presumption is great. There's just recently in 2024, a Kentucky Supreme Court case on this issue. It was out of Breckenridge County, if I'm not mistaken. The site on that is 2024 WL 298. 2769. That is a case in which, much like we are sitting here today, the defendant was charged with capital offenses. The Commonwealth had made a statement on the record they were not seeking death in that case. That statement made at that point in time, the judge set a bond over the Commonwealth's objection. The Commonwealth then filed appeal on that issue. Supreme Court come back and did the exact analysis they're asking you to do. And basically, what he did in the community, what he did is irrelevant. The only thing that's relevant is, in fact, the charges themselves. And the Supreme Court said, if you are charged with a capital offense, you are not entitled to bail. And they overturned a circuit judge and sent it back to no bail. So there's a case already out there the Supreme Court issued last year. I gave you the citation for it. And the case number on that is, or the case name on that one, I don't think I gave you that, is Commonwealth versus Rodney Jones. And Judge, there's enough in the record already. You can take judicial notice. That's why the Commonwealth introduced the video here at the preliminary hearing.
Right.
It's very clear what happens in the preliminary hearing. They were counseled record at the time, so there's not an issue. They did cross-examination of that. The record is very clear. The video is very clear. And Mr. Stines, in fact, took the life of Mr. Mullins. So,
Yeah, and then he brings up the fact that you're not entitled to bond when you're charged with a capital offense. All very important. Sherry, if the victim was not a judge, do you think he would have a better chance for a bond? I saved this question until we just heard his argument. No, I think it'd be exactly the same. No bond. He shouldn't get a bond. I don't know, subjectively in this judge's mind, if it would make a difference, but legally speaking, no, it shouldn't make a difference at all. Peter, please cover the new email from the whistleblower in Idaho 4. So I don't know what this is referring to. I don't know if this is with the stuff that was leaked to the news, but I've seen some videos coming out about Brian Koberger. Some people say maybe AI enhanced and things like that. Brian Koberger potentially complaining in jail. Some of you have sent me that. Again, haven't really been able to dig in. It's going to be really hard this week. I may be able to have some time at night to record something or maybe even go live. I don't know, depending on what witnesses I have the next day in the trial. But so it'd be hard for me to really jump on anything that pops this week, but still send it to me because, again, I might have time at night, next weekend, next week, whatever. We'll find the time and still talk about everything that you guys are following here.
that's all required. Even under the case law, the Constitution, he is not entitled to bail.
No, if I could
Sure.
briefly respond. I do have a piece of case law I can cite here, Judge. It's Burton v. Commonwealth. It is an older case. It's 212 Southwest 2nd, 2010, Judge. Does show that the court can take into consideration the mental state of the defendant when setting bond in a capital case. So if this case was basically where evidence introduced in a hearing on motion for bail showed defendant to not be guilty of murder, but only voluntary manslaughter, in the event that the jury did not find self-defense, the proof of guilt was not evident, nor the presumption, right? So I think the court can take that mens rea into consideration and that mental health evidence into consideration, which is again why we want to be able to introduce that.
All right, thank you. In response.
Judge, I believe the case law cited speaks right to the issue.
All right. All right, as with the other issue, like I said, here's what I'm gonna do. Mr. Steele, you said that you all would file a written response on the KCPC evaluation within 10 days. So,
On a motion to unseal?
yeah,
Yes, sir.
why don't we do this? If anybody wishes to submit case law or supplement anything in regards to the pleadings on all three of these matters, if both sides will do it simultaneously within 10 days.
Within 10 days, Your
Within
Honor?
10 days.
Yes, sir.
Yes, sir.
And then that'll give us time. I'm gonna try and expedite rulings on this, and then we can start looking realistically more at setting a next hearing. And I think once we get these initial matters addressed, we can then start realistically looking at potential trial date
Yes, sir.
for all parties. So.
One thing,
Sure.
Judge, can we do 10 days from Monday, since today's kind of
Yeah,
shot next
10
week?
days from- Why don't we do this, 2 weeks from today?
Yes, Your Honor.
That work?
Yes, Your Honor.
Yes, sir.
Or do you want the weekend and add one more Monday?
I'd
Mostly
rather,
your motions.
under promise and over deliver, Your Honor.
All right, why don't we do this? And both sides will have till Tuesday, September 2nd.
Yes, Your Honor.
That should give everybody plenty of time.
Thank you, sir.
All right, and then after I get those pleadings, I will notify the parties and we'll get a more realistic timeline on when we'll set the next hearing. All right, other than these three matters, I know we have one matter that we'll have to address ex parte that we'll talk about in just a minute. And for purposes of record, the Commonwealth, you've been given notice that they filed for an ex parte hearing in regards to funding.
Yes, Your Honor.
All right, and you're aware that the court will address that at the conclusion.
Absolutely, Judge. And just to make the parties aware of talk those in chambers, we are looking for an expert on this issue. And
Sure.
and there's funny channels we have to go through depending on what those come back as for an expert also. So we made counsel aware of that also.
All right, thank you, Mr. Steele. Anything else we need to address today before we adjourn before the ex parte hearing?
They'll continue to come.
All right, ladies and gentlemen,
All right. So that's it. And now they go in for the ex parte hearing. Debbie said camera guy is fired. I remember that, like just flash, 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 flash at the end. It was kind of crazy. But yeah, so the next part, they go ex parte, which obviously is something that we can't watch. I expect the judge to deny the motion to dismiss and deny bond for Sheriff Mickey Stines. And we're going to continue going forward on that case. Like he said, once we get some of these preliminary matters done, then we can kind of get a trial date and start moving stuff along. Going to be a lot of mental health experts. That's what it's all going to rely on. Eventually, maybe the state will offer a deal that includes some lesser included that maybe they're convinced with the mental health issues. If not, I think it goes to trial because he really doesn't have much to lose. So I appreciate you guys so much for being here. I appreciate you coming to hang out. I appreciate everybody reaching out, sending cases, even if it's Turtle Boy case, right? Even if it's a case I don't end up covering or I don't cover until it goes to trial, that's fine. If you guys have questions on it, let me know. You know how to get cases watched on this channel. When you have questions and it's interesting and we can talk about it and there are documents for us to discuss and learn from, that's how we will do it. That's how we will continue to do it. I love hanging out with you guys. I love coming talking about these cases. Please hit that like button and make sure you're subscribed to our page. Till next time you'll see me. Hopefully it's after the trial and hopefully we win. I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.